All right. Well, I'd like to welcome everyone to the actually final Strauss Center International Security Speaker Series talk of this semester. That is not to say that it's coming to an end, because of course, what's after every semester but another semester? And I do hope you will join us. We have a great lineup planned, starting with Amy Ziegert in January, who'll be talking about intelligence reform. So I mean, the things don't stop. Please stay with us. But for now, I'm welcoming you to the last one of the fall semester. It's my great pleasure to have David Rivkin here, and for those of you who've been looking forward to hearing David, we apologize for he's hopefully not going to follow up with more apologies. This is the only time I'm hoping that we're going to apologize that we had to reschedule this event. But in real life, when he's not talking to crowds like this, he's a high-flying power lawyer. And those of us who are academics complain all the time about our schedules and not having control, and oh, we're so busy. But he actually doesn't have control of his schedule to the extent that we do. I mean, we have it easy, and he was legitimately called away and couldn't be here, and we're very sorry about that, but I'm glad you could come today. David is a real standout expert and very well-known personage on the kinds of topics that we're going to discuss today. You can, he's a lawyer, as I said. He served in the Reagan and first Bush administration, so he's a lawyer with particular government and policy experience as well. But in his continuing practice, he's concerned with influencing public debates about national security policy and sometimes foreign policy and defense policy and other issues. But he frequently writes opinion columns or op-ed columns, or appears on news programs where he's frequently called upon to debate these issues. And he's very eloquent in presenting a clear position that many people disagree with, and that's very important to contributing to the kinds of discussions and debate we have in the United States, and also what the Strauss Center is about, is clear statements of important opinions on important topics. And so today, we're going to hear what has been previewed in a couple of op-eds recently in the Wall Street Journal, among probably some other places. David Rivkin's argument for why executive power is under siege, which I hope will stimulate serious discussion in a place which often thinks about executive power soaring. And so I think this will be a very interesting discussion. And without further ado, David Rivkin.
Thanks very much. Thank you for the kind introduction. I hope I can live up to my billing, and I'm glad this is not the final Seinfeld episode, just the final episode for a good season. I really am going to enjoy talking for a little while with you and then having some discussion about an issue which I think is very important and really kind of an organizing framework for a lot of specific issues, specific debates you may have been hearing about lately, and namely, what is the proper constitutional authority to be exercised by the executive branch of the United States government, and whether this administration has in fact exceeded the proper constitutional parameters of its authority, which is the common perception, certainly that of most critics, or not, as I would argue. It certainly is a great venue for discussing those issues because LBJ School of Public Affairs is named after the president, who was quite unabashedly a serious both student and the practitioner of the use of power. It is somewhat ironic in my view that perhaps to some sense, the debates about executive power perennial go back to the very founding and certainly Federalist Papers and the so-called Pacificus Helvidius debate, pitching Madison against who was doing Jefferson's bidding. Jefferson was too much of a gentleman to sally his hands of that sort of thing against Hamilton. But to me, the current round of, shall we say, demonization of executive power actually dates back to LBJ. At least to me, sort of, one can make a case that the date where it all kind of began was November 22nd, 1963, and that's the day John F. Kennedy was assassinated. And the reason for it is from perspective of much of intelligentsia. Kennedy was, in addition to being a great president, was their president. He was Harvard educated, he was personable, stylish, funny, eager to surround himself with the best and the brightest. His campaign was certainly what was well run, but also the kind of a crusade of youth and vigor and good intellectual cheer. His election, in the eyes of his Ivy League backers, was a true passing of a torch to this very able generation of leaders who would change the world. Indeed, Kennedy said so much in his excellent, well-written, well-delivered inaugural address. Well, then the sun set on November 22nd. Kennedy was dead. LBJ was the President of the United States. And undoubtedly, LBJ had many virtues, and I would not claim otherwise, especially given where I am today. But he was certainly not Kennedy in most respects. He was not, and perhaps in many respects, he cultivated the image of not being Kennedy. He was not an Ivy League graduate. He looked, acted, and talked like what he was, which is a Texan. He was certainly a very able politician, one of the most skilled and successful managers of U.S. Congress in history. He actually, ironically enough, as the president, achieved far more, in my opinion, for a progressive agenda that Kennedy would have likely attempted to achieve, or perhaps even wanted. Among other things, he pushed the Civil Rights Act for Congress, along with a raft of social and welfare policies dubbed the Great Society. Yet, for the fans of Camelot, LBJ would always be the other, never Jack Kennedy, no later even his brother Bobby. And then, of course, ladies and gentlemen, we have Vietnam, which was another major catalyst. And, sort of one little vignette here that in July of 1967, Newsweek published an article about the rupture, the break between LBJ and the intellectuals, recounting the president's efforts to win back the intellectual elite defectors and predicting they would not happen. As one of LBJ's advisors explained at the time, that's a quote, the intellectuals would like to govern, but they're too weak and too abstract to be a viable governing force. President Johnson himself summed it up even better. Quote, presidents deal with power. Power is real, power is not pretty, and I guess these people don't understand power brokers like they do art brokers. I would consider doing this with a Texas accent, but it would be too appalling, so I would not try. Now, over the next 40 years, these people, about whom LBJ was talking about, never really did become a governing force. Time and again, their favorite candidates were defeated either in the primaries and general election, and of course we had a number of Democrat presidents during this time, including Jimmy Carter, but he was really never embraced as one of their own. It'll be clear in a second why I'm dwelling on all of his history, because it's kind of a prelude to where we're at today. Only in 1982 of the Clinton election, it sort of did a card-carrying liberal policy wonk, or at least a person perceived as such, entered the White House. And even then, in the eyes of a lot of progressive intelligentsia, his freedom of maneuver was greatly constrained by the Republican Congress. Elected in 1994, you all may recall the infamous or famous health care, if I said debacle, I tend to betray how I feel about it. Actually, I'm not particularly concerned about health care one way or another, but it certainly was a defining event for a lot of people. And in many respects, what happened with Clinton presidency, the triangulation, the tendency to move towards the center, was a textbook example for many of our progressive intellectuals about how difficult it is even for a good Democrat president to govern to satisfy the core policy goals and constituencies. Well, what do we have today? And in many critics, it's much worse than LBJ. We have an American president who looks, talks, and acts like who he is, which is a Texan, and sort of building upon this whole legacy, which I'll talk some more, it is not surprising that it's not just the president himself, but the presidency as an institution. Because again, we do have a unitary executive. The presidency has both symbolic and real power components, and it's inevitable that the two become enmeshed. But we have the presidency itself has fallen into serious disfavor with much of elites in the media and certainly in Congress. But as I think I already alluded to, if you look below the surface, there's a lot more here than personal disappointments and sort of dislike of President Bush's Texas style. There's more of an even clash of cultures going on here between Cambridge, Mass. and Crawford, Texas. Nor can the current animus, and I really see it as a fairly robust animus against most aspects of executive power, be entirely attributable, I should say, to be fair, to the alleged policy excesses of the Bush administration. Indeed, as I would at least try to convince you, it's not very often acknowledged, but this administration has been far more cautious in its exercise of war-related powers than its predecessor, wartime administration. And by the way, ladies and gentlemen, that's the right question. It's not comparing the behavior of this administration to behavior of the vast majority of American presidents, including folks like Grover Cleveland, who were fortunate enough not to govern in wartime. But if you look at the behavior of this administration, if you sort of tally up the alleged sins, the worst sins of this administration, if you look at Lincoln, Wilson, and FDR, I mean, it's not a question of opinion, it's a question of fact. It's very difficult to argue that they have not balanced or, let's say, aggrieved or sinned against the individual liberties as understood by the progressives more than this administration. And in some sense, it's unfortunate, while I'm a Republican and a somewhat partisan one at that, or I can set it aside. I really, ladies and gentlemen, wish it would be more personal to George W. Bush, because he's going to leave office in a little over in a year and it will be over. But I'm afraid that the anti-executive power animus is well entrenched and robust enough to survive, outlast George Bush's tenure. And I think that the executive branch under siege, which is the title I chose, is going to become a long-term fixture of America's political and legal discourse. And our next president, whoever he or she will be, will almost certainly face similar challenges to his or her constitutional authority. That's the case for a number of reasons, and I'll briefly articulate them. I think one of the major drivers of hostility towards presidential power is a fundamental suspicion of, even opposition to the use of exercise of American power as a means of defending and advancing U.S. interests at home and abroad, and in some respect rooted in a tendency on the part of some critics to see the U.S. basically as a negative force in world affairs. And this hostility is certainly shared on the left, but there is quite a few proponents of that view on the right. And to state the obvious, if one's goal is to constrain the U.S. ability to use power on the world stage, then it's the president that must be hobbled. The president is both the symbol of American government and also, as the framers of the Constitution intended, the mover and the shaker in the formulation and execution of American foreign policy. And, of course, those issues are particularly crisply presented now, since in the post-9/11 world, the U.S. has found itself in a state of armed conflict with a fairly ruthless and determined foe, and that has necessitated a pretty robust use of all aspects of presidential powers to defend the country. And accordingly, if you were generally inclined to be skeptical of a robust use of American power, you had numerous targets to shoot at in the last few years. Now, again, I'm repeating myself a little bit, but the disagreements about the nature and extent of presidential power and its relationship to Congress are nothing new. Americans have been arguing about it since the founding of the Republic. But I would say that, again, the vigor and the comprehensive nature of anti-executive sentiments and the prevalence of those attacks across the entire political spectrum is unprecedented, plus the substance is new in some respects. Let me suggest to you that those attacks on the executive power have taken three forms. One is the basic denial of the president's role as the ultimate repository of all executive power. a principle that is sometimes referred to as the unitary executive. 2, the promotion of a view of executive power that basically would configure the presidency or cast the president as a little more of an executor of Congress's will, rather as the head of a coordinate and independent branch of government. And 3, which is this one is really new, the view that courts should serve in a supervisory role over presidential decision-making, including most of the discretionary exercise of presidential power bearing upon national security, because otherwise, the quality of decision-making would be bad and civil liberties would suffer. And again, I want to emphasize that of the 3, the last one is fairly new. Well, let me take those things in turn. First one I would sort of call the one-man branch. Contrary to the Boston Globe, the unitary executive thing isn't new. It's not something that originated either in the waning days of a Reagan presidency or got dreamed up by David Addington or Vice President Cheney. In fact, the question whether executive power should be vested in a single elected official was one of the 3 or 4 sort of top-tier issues considered in the 1787 Constitutional Convention. And it's fair to say that not all framers were of a like mind on it. There was a fear expressed over and over by a number of framers that a single executive would inevitably gravitate towards monarchy. In fact, it's a nice quote that you can find in Madison's notes in the debates in the Federal Convention, quoting Edmund Randolph from Virginia, who was one of the certainly major framers. Quote, strenuously opposed a unity in the executive magistracy. He regarded it as the fetus of monarchy. Nice, colorful way of putting it. Not necessarily untrue. Ultimately, however, this position did not carry the day. Although a single individual vested of all executive power, rather than several individuals, a plural executive, or the disposition of executive function among other branches of government does partake of some of the elected monarchy features. Having a single individual was absolutely essential to accomplish one of the major goals of a constitutional convention, namely to have a government that can operate with a unity of command, speed, energy, dispatch necessary to protect the interests of a young nation. And I'm going to tell you what Alexander Hamilton wrote about the subject in the Federalist. And, quote, energy in the executive is the leading character in the definition of good government. A feeble executive implies a feeble execution of a government. A feeble executive is but another phrase for a bad execution. Close quote. So in other words, the framers adopted a unitary executive for a good and sufficient reason, having strong and vigorous government, which was, of course, very important coming under some pretty disastrous experience during the few short years under the Articles of Confederation, that executive power was essentially, such as it was at the national level, exercised by Congress. And as Hamilton described in Federalist 70, there were basically 2 ways of destroying the executive branch. You can vest executive authority in 2 or more hands, each with equal dignity. For those of you who remember Roman history, that's what the Romans have done with Roman councils. And it worked well on some occasions, but most of the times it did not work well. They were always quarreling, sometimes murdering each other, sometimes, most of the times, undermining each other. Or you can vest executive authority nominally in one person, but make that person's activities subject to concurrence by some council. Again, if you look at the British history, typically it was called the Privy Council. In either instance, you would have a pretty weak, or framers would call it enervated, executive branch. So unitary executive, again, far from being new, the unitary side of it reflects nothing more of an essential attribute of executive power, of a power to execute the law. In theory, of course, ladies and gentlemen, the president can execute the law, all federal laws by himself because his office is the sole repository of all executive power. Under the Constitution, the president may also control other governmental officers who execute federal law because their authority is derived entirely from his. And under the unitary executive theory, the constitutional status of those other officers is precisely defined. They basically exist simply because there's too much work for the president to do. by himself. And not even in modern times, that's kind of obvious, but even in George Washington days, it was pretty obvious. And in fact, George Washington himself said, quote, that the impossibility that one man should be able to perform all the great business of a state, I take to have been the reason for instituting the great departments, which we had about a few again compared with how many we have today, and appointing officers therein to assist the supreme magistrate, i.e. the president, in discharging the duties of his trust. So constitutionally, the notion executive branch officers should not serve the president in the sense of taking his commands, talking about lawful commands, about how to exercise his discretion is essentially illegitimate. I would argue, and not to make it too legalistic, if you look at the Constitution's first 3 articles, their wording decisively confirms this view. The vesting clause of Article 1, dealing with listing of congressional powers, has the nice words that says herein granted. So it's clear that we're talking about powers granted by the Constitution to Congress in this article. In sharp contrast, the executive power clause in Article 2, which defines the power of a presidency, lacks such language and talks about the executive powers. That, therefore, to me, even the New York Times not that long ago famously characterized the unitary executive as a fringe theory. It was dismissing, with actually very sort of little sense that this was unusual, strange position, actual intent, and the purpose of a Constitution framers, not to mention the plain meaning of a Constitution. Now, the context for the New York Times editorial was sort of a last-ditch effort to rally Senate Democrats to defeat the Supreme Court nominee, Samuel Alito, but there's also little doubt that this reflected sort of a broader doctrinal view of the part of the Democrat Party that New York Times is congenial to, that there really shouldn't be any power held by the president that should not be subject to the control by Congress. Of course, what Congress would do is Congress would delegate power to subordinate executive branch officers, and the only recourse the president would have would be to fire them, which politically, of course, is very costly. But he cannot tell them. The president cannot tell administrator of EPA or Secretary of Agriculture. I'm not even talking about so-called independent agencies. Cannot tell a lying executive officer how to exercise his or her discretion. So it's not enough that the president is subject to political checks and balances in the form of impeachment, not being reelected, power of the purse, but that Congress has this power to balkanize the executive and diffuse power. Well, again, to me, I think it's pretty clear that would be contrary to a framer's design, would produce a very weak executive. Now, I have to tell you, hopefully not today, but I frequently do encounter debating partners who would tell me that Congress in our constitutional system and any democracy enjoys superior legitimacy, that it's more representative of popular will, and there's nothing wrong with the president. In fact, the framers intended that the president be an agent of Congress in most respects. I happen to disagree with it, but to be fair to this view, it also does find a certain foundation in the if you look at the debates attending the framing, by the way, because framers disagree with each other on a variety of issues, you can find the support in the framing era documents for any proposition. But of course, that's not a good way to argue because a given view was argued and lost. To me, does not suggest that it is the view we should subscribe now. And you did have people, in addition to Randolph, you had Connecticut's Roger Sherman, who felt that the executive magistracy is nothing more than an institution for carrying the will of the legislature. But just as with Randolph's opposition to unitary executive, that view did not prevail. Indeed, it's more than that. The framers, you all heard, perhaps not, at least some of you have this notion that framers did not mean to create the king after suffering in the King George, that the sort of overarching, we're not creating the king should be the sort of a dominant principle of a constitution. Well, that, to put it mildly, is actually incorrect. If you look at the framers' concerns, they were concerned, of course, about abuses of power by any branch of government and understood that it would happen, possibly given human nature. But they were quite concerned about legislative tyranny. And Madison actually quite presciently wrote, in my opinion, I quote, experience has proven a tendency in our governments to throw all power into the legislative vortex. And he looked at the experience of various colonies, and he said the executive estates are in general little more than ciphers, but legislatures are omnipotent. If no effectual check be devised for restraining the instability and the encroachments of the latter, a revolution of some kind would be inevitable. So, in my opinion, the Constitution ultimately established a system of independent branches of government with complementary and sometimes competing powers. The branches do check each other, but none is superior. The President is Commander-in-Chief. Congress is empowered to make the rules for the conduct of the government. Where the congressional power ends and the President's power begins is not precisely delineated, and as a result is to be really resolved through the political process. The framers left this precisely the political process because, in many instances, not in all instances, many instances, there's no clearly obvious answer in advance. It's not that, again, while I'm a big fan of executive power, having worked for the executive branch, and that's certainly my cultural and intellectual bias, I would say there are instances where both branches are right in asserting their powers, and there's no sort of evil intent on either side. And in fighting these battles, it's important, maybe if you ask me about the debate about the contempt citations issued to the executive branch officials in the connection with the firing of U.S. attorneys, we can use this as an illustration. It's important to recall that then the President asserts his constitutional powers, like executive privilege, and Congress asserts its constitutional powers and sort of a necessary and proper attribute of its ability to legislate to get information for oversight. There's no presumption that one is right and one is wrong. They're both at least presumptively equally correct. So I've already said to you, I don't think that there's a valid view that congressional power is somehow supreme, and unless you can clearly demonstrate why Congress is wrong, the President should not oppose it. Well, let me skip for a couple of legal discussions involving Youngstown Sheet and Tube, which we can do during the question and answer period. But I mean, a lot of times people parse the case law and what the court has said for the prism of a particular viewpoint. And sort of, again, one of the big arguments of the critics is that the President is acting without congressional authorization. He's presumptively incorrect. And the only thing I would say here is that's actually not the holding of the famous Theo Caesar case. It's a little bit more complicated than that. Now let me switch to sort of the other big issue, which I mentioned, that a lot of critics these days tend to think that there is no legitimate area of purely discretionary presidential power, which is to say presidential discretion that should not be subject to some form of judicial review and, if necessary, correction. This certainly comes up in almost all litigation involving the war and terror issues, Guantanamo and whatnot, but more broadly in the view that the President's designation of people captured in this war as enemy combatants is incorrect, that they should be treated as criminal defendants, providing with a full panoply of constitutional rights that are enjoyed by such defendants, and that the President is wrong in his interpretation of relevant statutory law, but also key international legal instruments like the Geneva Convention. And the key part of it, I remember all the discussions about law-free zone and denying folks habeas, that all of it has to be subject to judicial review, and incidentally that the presidential efforts to intercept wartime communications and acquire sort of military intelligence are also subject to judicial oversight. And it's interesting, although similar claims have been made in the past during America's wars, I would tell you very candidly that in no prior war in American history have you had so many lawsuits brought while the war is still going on, challenging every aspect of intelligence collection, be it electronic intelligence, be it interrogations, be it detention and handling of enemy combatants. And while the executive has won virtually all those battles, at least some of them have not been 100%, and they're still going on. Now, traditionally, of course, presidents have exercised their greatest power with respect to these types of issues in wartime. As Justice Thomas wrote in the 2004 Humvee versus Rumsfeld case, where the captured Taliban fighter challenged the legality of his detention as enemy combatant. He wrote, founders intended that the president have primary responsibility, along with necessary power, to protect the national security and to conduct the nation's foreign relations. He also pointed out the Supreme Court has long recognized his features and has accordingly held the president has constitutional authority to protect the national security, and that this authority necessarily carries with it broad discretion. Indeed, I would argue that, again, if you step back to the time of a founding, it was clearly understood by the framers, who were inspired by a number of political philosophers, including Montesquieu, discretionary governmental power can only be successfully or ably exercised by the executive. Because what is discretionary power? What does legislature do? Legislature passes laws that sort of provide broad antecedent rules to apply in circumstances. But while Congress does oversight, this is really an aid of new legislation. Congress does not, legislatures do not exercise and cannot exercise discretionary power. If anybody can exercise it, it's the executive. And yes, it's true that discretionary exercises of power can lead to abuses, but the framers divide the sufficient and proper constraint for political accountability, not by having either Congress or the courts share in the decision-making process. Indeed, I mean, I would argue that at least in theory, the unitary executive is quite accountable, far more accountable in a democratic sense than any other branch of government. There are clear lines of authority that flow to the president. And as Hamilton urged his colleagues in Philadelphia, the unitary executive is a responsible one. Quote, the executive power is more easily confined when it's won. And Harry Truman, I think, put it somewhat more bluntly when he said, with a famous sign on pointing to his desk, that the buck stops here. But in both cases, the sense is the same. The executive's broad discretion inevitably carries at the price that he is accountable for all the bad things or perceived bad things that were done by his subordinates. I don't think I need to belabor this point. You can all think about Iraq War. You can think about Katrina. You kind of stuck with what your subordinates in the executive branch have done. Well, that situation, I mean, tell me if you disagree, is vastly different with regard to both Congress and the judiciary. Federal judiciary, of course, by design, I'm not saying that it's a bad thing. There's no accountability, except in the most extreme cases. There's no appeal from a Supreme Court, and frequently precious little from lower federal courts. Impeachment of all theoretically possible judges has happened only very rarely in our country history, and usually unsuccessfully. And if you want to sort of paraphrase Truman's statement and try to apply it to the court, you would have to conclude that the buck, so to speak, simply doesn't stop when it comes to the courts. On Capitol Hill, by contrast, the buck kind of gets lost. It filters for a chain of committees and subcommittees, procedural complexities, and political maneuvering. The leaders of both houses of Congress are not in charge of their branches of government, but sort of have a status of first among equals. Ditto for committee chairman. We have 535 members of the House and the Senate to choose from, and most of them cast, and they often help each other. Multiple and conflicting votes to get some political cover. So it's darn difficult to affix responsibility for bad decisions. And it's fundamentally explains, in addition, of course, it's both accountability as well as ability to operate with speed, unity, and dispatch, that the frame is vested discretionary policy choices in one easily identifiable individual, and that is the president. And again, the notion that the president should have broad executive discretion has long been a settled rule of constitutional jurisprudence. Fortunately, in 2002, in the case I mentioned, Justice Thomas was not in the majority. He was in dissent. Majority of justices having agreed that some form of process, albeit one formulated and administered by the executive, was required to permit detainees to challenge their classification against as enemy combatants. Incidentally, I don't have a problem with this degree of process of a judicial involvement in it, like some of my friends. The problem is that I don't think the courts have stopped there, and we're now facing another argument in the Supreme Court on December 5 in a different case, which I can talk about more if you're interested during the question and answer period, that would be far more prescriptive and proscriptive about what the executive should do in this area and how much the courts hold sway. There are arguments quite often made these days that the President's interpretation of key international treaties, like Geneva Conventions, and how they apply to a conflict with al-Qaeda and Taliban are subject to judicial review. Now you can say to me, gee, I mean, haven't courts been involved in interpreting and applying statutes? Yes, they have. They have treaties, excuse me. They interpret and apply treaties in most instances where you have clearly cognizable and justiciable rights of individuals. On the other hand, traditionally in cases involving treaties like Geneva Conventions, where the rights are really held by nations and not individuals, it's been always pretty much up to the chief executive to construe and apply American treaty obligations or withdraw from treaties or derogate from them in some form or suspend them. Briefly recall the whole controversy about NSA's warrantless surveillance and the extent to which the President deviated from something called Foreign Intelligence Surveillance Act, FISA. And again, we can argue about whether or not what the NSA has done did or did not comply with the statutory language of FISA, and there's some good arguments that it did. But fundamentally, the notion that Congress passed a statute in '78 that entirely constrained the President's inherent authority to acquire, and again, we're not talking about peacetime, we're talking about the President's ability as Commander-in-Chief, essentially to acquire battlefield intelligence, is quite remarkable, especially because despite everything else that went on, that authority has been upheld by many courts, including FISA's own appellate chamber. And we are in the middle of a debate now where we are having people on the Hill pushing for ever broader version of that authority, where FISA judges would have to preside in some form over warrantless surveillance of foreigners, ladies and gentlemen, overseas. Not as intrusively as in the case of Americans at home, but enough, which certainly has never been done. And the underlying sort of philosophical premise that it's good for the courts to be involved in such things. That, as I mentioned in my introduction, they would enhance the quality of executive branch decision-making. Otherwise, you have this insular executive branch culture, groupthink at the White House, the president being out of touch. But also the courts can protect liberty better. That, again, interesting argument. And unaccountable judges who render, in this case, secret decisions where you don't even know who a judge is. Nobody knows the name of a judge, for example, who held earlier this year that the particular type of warrantless searches, including individuals overseas, if information is captured here, are subject to FISA. Nobody knows who that person is. So it's interesting that decisions, secret decisions by unaccountable judges can do more to protect civil liberty than decisions by accountable executive branch officials. I think, again, it's horrible as a matter of policy consequences, but it fundamentally deforms our constitutional system. Just a couple of points, and then I'll stop. You may wonder by now, why would Congress do that? Why would Congress sort of empower judiciary to do this? Because in some sense, it would not seem to be in Congress's interests. After all, Congress, in the past, certainly, in the previous battles of executive, wanted to arrogate more power to itself, to have a bigger seat at the table. That's the kind of debate that goes back to the founding. But there are actually a couple of distinct reasons why Congress believes that it's work here. Because while giving a lot of power to the courts to cabin the executive exercise of discretion or power would seem to reduce congressional authority, it also significantly reduces the political risks attendant to the exercise of authority. And the decisions here, of course, are very difficult and controversial ones. Civil liberties are clearly implicated here. I will not deny that. But we're also talking about things like detention of captured al-Qaeda and Taliban members, interception of al-Qaeda communications. They're by and large popular with a large chunk of the American electorate. And reining in the president, if Congress did it, which it certainly can by exercising the power of a purse, carries high political risks. Now, I would argue, ladies and gentlemen, was risky because this precisely because framers wanted them. They intended Congress when checking the president, what Congress can always do. Congress can bring the president to his or her knees, but should do it in a transparent fashion and therefore politically accountable fashion. So you pay the price for it. If you, for example, cut all the funds for NSA to do warrantless surveillance, and we have another 9/11 style attack, and it turns out we had somebody in custody, or no, sorry, that's a different example, but let's say you cut off NSA's ability to do warrantless surveillance. Some information does not come in, dots are not connected. We have another 9/11 commission, and it concludes that these actions contributed to horrible casualties on American soil. That would not be good for the folks who did it. Even exercising vigorous oversight, which Congress has done certainly in the era following Vietnam, entails high risks that Congress would have to take responsibility for those actions, which is why, by the way, then the Congressional Intelligence Committees have been, we can debate how well they were briefed, but largely briefed about various controversial things. And they really didn't say beep until things leaked. Because, again, if you take a position, if you resign, if you go public, if you go in the well of Congress and say on the speech and debate clause, I'm immune from criminal prosecution, I'm going to, disclose this program that trenches upon individual liberty, you have a huge political price to pay. By contrast, when you have judges do various things, whether in secret, and some of which things are done in secret, or even in public, there's no skin off Congress's nose. But second, and so my last point is there's also a kind of serious ideological component, which I keep returning back to. If you assume that the vigorous exercise of American power overseas is a bad thing, we're largely not a positive force, it needs to be cabined, you really want to constrain that the right way to do things is for multilateral institutions and coordination, Security Council blessing. Whom do you want to constrain? Not Congress, not the judiciary. You want to constrain the president, because in our scheme of government, it's only the president who is capable of directing American foreign policy in this unilateral and therefore sort of inherently suspect fashion. And the best way, difficult for me to imagine what's a better way of preventing the president from doing it, or at least encumbering him, by having the courts supervising his actions. Courts are deliberative, they take time, there are lots of them, they have no way of obtaining intelligence or analyzing it, they're not cohesive, et cetera, et cetera. Let me say this in closing. I would point out that whatever you think about the specific policy issues that have been debated in this great body politic of ours, there's enormous significance to keeping the presidency strong as a viable institution and not getting into the habit of undermining or feeling there is something fundamentally illegitimate about the exercise of those powers, both because of utilitarian reasons, because it's a tough world and we need to be able to act with speed and dispatch, but also because, frankly, it does seriously distort the constitutional fabric that framers have laid out. And if this country is about anything, it is, in my opinion, at least about the fidelity to this fabric. It's not about specific consequences or policy results. It's about processes and procedures. Well, let me stop here and let me hear why you think I'm wrong, and maybe some of you might agree with me, which would be a nice thing. Thank you.
So we would love to take questions and discussion, and please identify yourself and important or relevant affiliation.
I'm Tom Pangle from the Government Department here. It wasn't entirely clear to me from what you said why you're so convinced that this movement to weaken the executive is not targeted mainly at George Bush. Why, as you said at the beginning, you see it as a broader trend that will, as you said, affect whoever he or she is that is even the next president. The one thing it seems to me you did stress that goes along those lines is this ideological view that American power is fundamentally dangerous in the world, and you want to check it, and therefore, is that the one thing that you're thinking is the locomotive of this train, or what else is it that will make this same framework and outlook
endure?
Apply, let's say, to President Hillary Clinton?
Right. By the way, it's an excellent question. Let me say two things. I hope it would not apply to President Hillary Clinton. I would hope if she wins that she would have a most effective and energetic, non-enervated executive at her disposal. But I'm afraid that's not going to happen in its case for several reasons. One is this sort of ideological driver related to the people's conception of American role in the world. Second, another cultural and political tendency to view the courts as the engine of social progress and ever-growing tendency to view litigation as the best, superior to the political resolution, legal and judicial resolution, the superior way of resolving all things that we've been doing. Again, whichever you think about the policy consequences of that on socioeconomic and cultural issues. And I'm, again, not to disarm some of you, I'm fairly agnostic about those issues. I really am not sort of jumping up and down about courts, legislating in these areas. But if you live in a society where that is a common thing, and you identify because of the media and various other things, the courts as the engines, the ultimate guarantors of civil liberty, it is pretty difficult not to reach the same conclusion when it comes to other things. And I mean, let's be fair, we're not talking just about abstract issues. When you detain people and hold them, in unpleasant places, and I've been to Guantanamo twice, it's, in my opinion, a better place than any federal or state penitentiary I've seen, but it's certainly an unpleasant place. Because you deprive people of their liberty, then you eavesdrop on people and sort of penetrate the cone of privacy, which we've come to venerate, again, because of domestic legal developments. It's jarring to our 21st century sensibilities. And you clearly have to cabin the executive. And what's ironically also happening, and again, I already said all that, but I'm just putting it together slightly differently to answer your question, the very unwillingness of Congress to really step up to the plate and squeeze the executive is leaving the courts as though they're the only other relevant player. I would be delighted if Congress wanted, well, no, that would be a lie. I would be more simpatico. I would be delighted if a president essentially was left alone to do what he or she sees fit and was held accountable for broad checks and balances we have. My second preferred option would be a vigorous congressional oversight where you really, really said, all right, I want more than not every member of Congress, but more than a gang of 8, maybe a gang of 12, a gang of 20. I want to be present on all the decisions. I want to have briefings about everything that's happening on the national security side every week. I want to necessarily have the same treasure trove of decisional information as the most senior members of a president's team. And by golly, if something is really wrong, I'm going to make my voice heard. Congress was willing to do that. That may, despite everything else I said, be sufficient to satisfy this yearning for having a countervailing force. But Congress is zippo interested in that function. So since we have no fourth branch of government, despite what some people have described as somewhat whimsically in independent agencies, courts don't mind. Boy, they certainly don't mind. There are some judges are quite, content to dismiss cases because of lack of jurisdiction or political question doctrine or some other, lack of standing or lack of ripeness or deferred executive invocation of state secrets privilege. But many don't. They're happy. So it's kind of a classical marketplace thing. You're yearning for something. This store is closed. You don't like just shopping here, and this one is open, so you go here. So it's a lot of things that drives us in that direction. I mean, I can, without naming names, I can tell you another problem we have is we have enormous tendency now to do, even some critics of Bush administration acknowledge it, to criminalize policy disputes. I mean, that's not a new term been used during the Iran-Contra, but it's really bad now. You cannot literally do anything serious on the national security side without getting lawyers' opinions. Okay, I'm a lawyer too. What's the big deal with that? The problem is that we both simultaneously created an impetus for a lot of legal opinions, and then what we've been doing in the last several years, we made life very difficult for lawyers who had the gumption to issue opinions that people don't like. And you probably can imagine the names of the people I'm talking about. They're ostracized, they're picketed, their students are protesting that they're taught. If they teach classes, they would not be confirmed for a dog catcher in any administration. They don't get invited to, lecture for lucrative fees. They don't get sexy book contracts. It's not a good place to be in. And the more, by the way, Congress, let me be a little cynical, one of the reasons Congress is clamoring for all the legal documents, Congress has been briefed. The intelligence committees have been briefed on everything that was done substantively. But they want to know legal opinions. In my opinion, I could be wrong, one of the reasons you want to know the legal opinions, including drafts, because you want to know who wrote them. because you want to make life absolutely bloody miserable for everybody who wrote them, whether they're career political people. So I said to a very good friend of mine, who's remain nameless, who's a big-time Democrat, that I really wonder if Hillary Clinton is president, where she's going to find the head of OLC who'd be willing to, sign an opinion that would give her some answer she's looking for. I don't think she would have an easy time finding such a person, given what we've seen happen in the last few years. So that's another problem, because actions have consequences. You just can't just completely abandon everything that's been building up, sort of accreting in our political and legal system. I would hate to be the head of OLC now to answer a tough question. But if you say no, you're a brave man. You speak truth to power. By the way, I get kind of angry when I hear this argument, because believe me, if you look at the consequences, and let's assume everybody's a person of integrity, it's far safer to say no to the White House if you look at what ultimately happens to your career. You get lionized. But if you said yes, and folks know who you are, you're in trouble.
Please.
I have a question that really bears on my understanding of your argument. And for the purposes of that, I want to use the FISA statute as an example. Now, I wasn't sure from your presentation whether you take the view that the administration was in violation of FISA or not. Let's leave that aside if we accept for the purposes of argument that it was. FISA requires that it come before the court to get warrants, and they didn't do it when they should have under the terms of the statute. Just for the purposes of argument, if you'll go along with me that far. My question is it your view that in wartime the president has the authority to order that violation of the statute, and further that the president has the right to decide, absent a congressional declaration of war, that we're in a state of war, so that those two powers are inherent in the president, in the presidency. Is that correct?
I understand the question. In fact, it's probably not saying it to be collegial, but it's better worded than the several questions that Judge Mukasey got on the same subject. Let me do my best in answering. By the way, I'm interested in FISA. I've written about FISA, but this is at least not my understanding. A heavily legal audience. I can talk about language of FISA. Let me make a broad argument, but if you wanted me to be more specific, let me say this. First of all, I happen to think that there is a statutory compliance argument that can be made relative to TSP, the Terrorist Surveillance Program. And that, in fact, is the argument that was made by OLC under one regime, so to speak. And then that argument became more difficult. You pivot off the language about reasonable expectation of privacy, because if you look at that as a sort of... so you don't want me to talk about statutory compliance. All right. Let's say that there are some surveillance regimes, but clearly cannot be tweaked to fit within the percussion bed of FISA statute. Then you're asking me a question, okay, can the president order a violation of a statute? Well, the short answer is depends. If a statute purports to regulate either in all circumstances, and that would be a facial problem, always called facial problem, or in a particular set of circumstances, as applied basis, the president's constitutional powers. But of course the president has both the right and even a duty in some circumstances to order his subordinates to disobey it. By the way, that also wasn't invented by David Addington or Dick Cheney. There's an excellent, in fact, my good friend and respected colleague Walter Dillinger, who was Clinton's solicitor general and the head of OLC, wrote a memo, slightly paraphrasing, the title of it, "The President's Right to Disregard Unconstitutional Legislation."
And supposing the constitutionality is tested and the court says, okay, that law is a good law, you have to...
Well, just one thing. But that's an excellent question, but just to finish, because you ask also, if it's not, by the way, I don't think that FISA, unlike some people, is facially unconstitutional, meaning it doesn't FISA properly construed does not intrude upon the president so much as to be unconstitutional. It does intrude on the president a bit. Again, I'm considering myself a
neither here nor there.
But in terms of in a wartime, if you ask who determines it's wartime, that has always been determined in the first instance by the executive applying rational tests And I've argued and written about the proposition that given the international law definition of a state of armed conflict, which is not a little bank robbery, not some minor unpleasantness, but you look at the factors of how many people were killed, is power being projected on a scale comparable to, military activities, activities being carried out on the political. Bottom line is this: I don't know many serious. Well, I shouldn't say. I am of a view that September 11 certainly did usher in a state of armed conflict. The fact that Congress passed something called AUMF, Authorization to Use Military Force, certainly brings within, to me, the Youngstown, Sheet and Dubes framework, congressional imprimatur. The fact they didn't declare war is not ultimately dispositive. So yes, the FISA, if FISA is construed the way critics construe it, to apply in this situation, it is unconstitutional. The president has an obligation to disregard it. Let me just give you a hypothetical. I'm not a law professor. I like it as much as any law professor. If you take the view that FISA is the exclusive venue for regulating government intelligence on American soil, would you think that if we had, for example, an invasion from Mexico or Canada, or we had some, another, bandito-type expedition that seized the town in Texas, that the president could not gather battlefield intelligence directed against that invading force or that band of people without going to the FISA judges?
Well, FISA is about surveillance of Americans.
No, for the way FISA works, with all due respect, if it's an American soil.
Again, I'm not going to get into an argument with FISA. The basic answer to the question is, in a state of war, the president has the power to disregard the law. That's your view.
No, no. The president at all times has the power to disregard statutory law that contravenes the Constitution, because the Constitution is the highest law. If something is in violation of the Constitution, it's null and void. Whether or not, sir, a given statute violates the Constitution sometimes is fact-specific. Are we in a state of peace or in a state of war? And sometimes it's not. Sometimes it's, unconstitutional all the time. So it's not the violation of the...
I've got to leave it. A state of war is a condition which gives the president the authority to disregard statutes, basically on his interpretation of the Constitution.
State of war gives the president an authority to disregard those statutes that, upon his interpretation, I don't know whose else interpretation it would be, certainly not Congress's interpretation, because each branch has an independent obligation to comply with a Constitution that trench upon the Constitution. And it's not violation of the law. Constitution is the law. Now, the most difficult question is if definitive adjudication by the courts produces a contrary result, in my opinion, the president has to recede. And it is the emphatically duty of the judiciary to pronounce what the law is. Slight paraphrase, but I agree with that. But this is very important. Most of those issues would never be justiciable. And in the absence of judicial resolution, at one point I wanted to make emphatically is Congress's view as to what Constitution means ain't any better than the president's view. I'm not saying it's any worse. It's a political dispute. So I alluded to the business of contempt citations. Here's Congress asserting, let's assume in good faith, that they want to know some facts about what happened at the Justice Department. Here's the president asserting in good faith that he needs to be able to shield deliberative discussions both for himself and the sake of a presidency. And he cannot release it. You know what? Both are right. And the proper way to deal with it is to have Congress go to the courts and try to enforce the original subpoena. Issuing contempt citations presupposes that there is something inherently wrong about the executive branch officials obeying the president's decision not to do it. There's nothing wrong about it. And there's nothing wrong with Congress doing it. Both are acting within their respective spheres. Results clash, and it's either a political fight or go to the courts. But most times you just cannot go to the courts, as the framers intended, because most of the structural separation of powers issues are not justiciable.
Working on my capstone this semester, specifically on FISA. So I'm really glad I came to this. Actually, I have a question about recent changes to FISA that are scheduled to sunset in a few months.
Protect America Act.
Exactly. And basically one of those, it was to get rid of the warrant requirements. So right now, they don't have to get warrant requirements, which is basically based on the media leak that we found out 2 years ago. was what the president has been doing since 2001. So I guess my first question regarding that, what we found out about the NSA program, is how would you characterize that as what you call a cautious approach to the use of executive power by this administration? And my second question is also how you pointed out about how the courts, like with the court oversight, there's less accountability as opposed to the accountability that the president has. So now, how will Congress or anyone else be able to evaluate the usefulness of FISA without the FISA court when it's already done in secret and you don't have access to those records?
Right. I'm somewhat tempted to make some pedantic observations about the fact that the way you describe, with all due respect, what Protect America Act does, what happened before is not quite right, but that's probably not the most important thing. The most important thing is this. Presidents throughout American history have engaged in all sorts of surveillance, particularly in wartime, without any restrictions whatsoever. You had Congress come in '78 and pass a statute that, if you read it fairly, covers a fairly narrow spectrum of surveillance. In fact, FISA, as originally drafted, essentially regulated differently. It created a very different framework for outward-directed intelligence gathering and intelligence gathering on American soil, using as proxy the fact that tapping the wire is what FBI and domestic law enforcement entities did on American soil. And the NSA, National Security Agency, relied on satellites and ground listening stations in other countries. And that's why these are really proxies for different types of surveillance. And everybody understood, including the critics, this is at the time there were serious problems with the Nixon administration and its predecessors, maybe bipartisan, and surveillance of enemies and sort of misuse of national security as it were political combat. So Congress correcting that, if you look at the legislative history of FISA, had fulsome statements saying we just intending to regulate this and not that. And it's wonderful that NSA goes out and vacuum cleans millions and millions of communications. Okay? Fast forward to today, where we were before the Protect America Act passed, is because of a quirks of technology. And again, I don't unfortunately have all evening, but basically, if you think about it, with fiber optics, the bulk of communications, international communications, no longer goes over the air and gets plucked by satellites. It goes for fiber optics networks. And because we have the most robust and resilient networks for most switching stations, something like 40+% of global traffic goes from American fiber optic systems. So when you have somebody in Hamburg calling somebody in Ouagadougou, chances are 40% is going to go for American network. And we had geniuses in the FISA court who apparently decided that because it was a domestic intercept, tapping, geniuses, I mean sarcastic, you can make a perfectly reasonable legal argument if you want to be very, precise about the language, that is subject to a warrant. But what we have, far from, because you said, well, how is this president being restrained? For the first time in American history, the totality of warrantless surveillance got shoved into the FISA court, which is horrible from numerous perspectives, including the fact that a warrant, it's actually in the FISA parlance called an order, means something. It's not a rubber stamp. By the way, if it was a rubber stamp, what good would it do? And how the heck are you supposed to get orders/warrants when you don't know who the people are you're listening to, because you're looking for things and connections? You don't know their names, you don't know their gender, you may not know where they are. How are you going to go and ask a judge for a warrant here? It basically rendered us incapable of, if you take what the government tells you seriously, you don't think they're lying all the time. Director of National Intelligence, Hayden, said that, our stream of intelligence dried by 70+% once that ruling was issued by a judge whose name we do not know. And all that PPA, Protect America Act, tried to do is not to abolish the warrant requirement, but say you still need a traditional warrant order in these circumstances, but not when you're doing this other stuff. But what Congress is going to do in the end, in my opinion, is not even going to be like in the Protect America Act. They're going to straddle the fence. they're going to put the FISA court in a position, and I'm coming to your last question, going to give a FISA court a chance to do serious traditional warrants for this portion of the spectrum. And then they're going to do something really funky. They're going to say for all the other stuff, we cannot get a traditional warrant. We want the FISA court on a retroactive basis to read what Director of National Intelligence and the Attorney General certified. Okay, if you look at the language of a statute, what was the FISA court supposed to do in that situation? Unclear. It doesn't really say that. But my favorite is, because you said, how would Congress do? There are extensive reporting requirements. Each element of the intelligence community is supposed to have a person whose job it is to sit and ask everybody. Presumably they'll tell them the truth as to what violations took place during this year. Okay, nothing wrong with that. And they get reported to Congress. Nothing wrong with that too. It's called oversight. But Congress decided that it should be also reported to a FISA court. Best of my knowledge, the first time in American history, a court is going to receive a quintessentially oversight type material. Well, what is the court supposed to do with this? Unless you think they're privy counsel. Not clear to me. Horrible stuff. Unconstitutional as hell, in my opinion. My prediction also, Kenley, I think the White House would sign it because of realities and power realities and the fact that, and power politics and the fact that the intelligence community really wants to listen to this stuff to protect us all. But, I mean, why did Congress even think that having the FISA court, I mean, they're going to get this stuff. Well, why do you want to give it to the FISA court too? It's a mystery. But your point is, how do we know? Congress gets, well, no, to be fair, not Congress in total, not even all members of intelligence committees, but the Gang of Eight gets the skinny on everything. And they could get more. There would be nothing wrong. I would see nothing constitutionally wrong if it were to say, I want to hear everything you hear, Mr. President, okay? I want to get every intelligence document, every briefing that you get. But something tells me that it's not what they want, because then what do we do with it? Back to accountability and political risk stuff.
I've been imagining that John Randolph was sitting over there and Arthur Schlesinger was sitting over there. Randolph, taking the basic premise, would say, yes, it has been a fetus of monarchy, and this fellow who's talking thinks that it should remain that, and that it should be protected against any erosion. Schlesinger, it's about a third of a century since the imperial presidency came out. Schlesinger would argue, well, I said imperial president is a dangerous threat to democracy. He's arguing an imperial president is essential to national security, to the proper interpretation of the Constitution. I want to reassure you, there is no unified attack on the concept of the unitary executive per se. I'm not talking about signing statements. I'm not talking about paraphernalia. I'm just saying that if you listen, as some of us have, and it takes great courage to listen to all the presidential debates, what I'm hearing is quite the opposite. I'm hearing people asking, do we have a candidate here who is strong enough, who can do the necessary job of restoring an international situation which is in need of amelioration? I'm hearing regularly, on both sides, Republican and Democratic, the search for a strong executive. I think you've been reading too many editorials in the New York Times. I don't think that is the sense of the country that is revealed on the eve of 2008. So I would like to suggest that what we have is essentially a government, it's no original concept, a government of shared powers, not separation of powers, and that the system works far better when there is, and I would agree with you that the role of the courts demands further examination than some of us have given it so far. But I would argue that the temper of the times is to ask to have a president who can carry out the responsibilities of Article 2 in the Constitution in a fashion that would not alienate potential allies, that would not jeopardize the role of the United States of law, and that would not, at the same time, fail to protect us from an age of terrorism in which we have not the traditional approach of wars between states, but a very new construct. So I see a search for a strong executive, and I'm the voice I want to encourage you, because I think that the basic premise of your argument doesn't really reflect the mood of 2007. Who knows what 2008 will bring? But for the time being, I think the temper of the country is to have a quest. It reflects a quest for leadership, not a desire to bring down tyrants.
May I offer my rejoice? First of all, let me say that this is the most interesting and stimulating rebuttal I've heard in a long time. There is some truth in what you're saying, and perhaps oh, thank you, and perhaps we're all victims of our circumstances. Let me sort of start with the last point, where is the center of gravity of a country. I would agree with you that the center of gravity of a country, diverse and heterogeneous and large as it is with a strong and energetic executive. Unfortunately, in this day and age, and that would require a longer time to get into, elites, and it's not just New York Times. For better or worse, I go out and I debate law professors. I belong to this wonderful organization called the Federalist Society, so almost every week, in addition to practicing law and doing other things like staying at home with my wife, I would go into Columbus or Cleveland or L.A. or Denver, and I would debate law professors. And I will debate people from Human Rights Watch and Amnesty International and Center for Constitutional Rights, et cetera, et cetera, et cetera. And trust me, it's not just New York Times. Most of those people find fundamental flaws with almost every single argument that we're talking about, ranging from the question of can Congress insulate from presidential supervision any statutory discretion that subordinate executive officers have? Can Congress micromanage and entrust to judicial supervision, intelligence gathering, handling of enemy combatants, and various other aspects of the use of force? They really say that. You're right, that's not where a majority of American people are, but this is maybe an inherent feature of democracy. Elite opinion matters. I solely wish that the view you're reflecting, I certainly am talking about, was the dominant view in the elites. I mean, does anybody think that I'm imagining things, that this is not the view of a legal academe, that I sort of created this straw man? But leaving that issue aside, on the issue of the candidates, because you have higher tolerance than me. I have not watched any debates. I'm actually not that keen on sort of hurly-burly and political combat, but I would say this. Details matter. In theory, everybody is for strong executive and strong and robust American foreign policy, however you define it, and that's not even, the policy issues, unilateralism versus multilateralism, that's for folks like Henry Kissinger to discourse about. But details matter. My big fear that we've created an environment, and I'm repeating myself, where Hillary Clinton needs a legal opinion from her Office of Legal Counsel because the Director of National Intelligence is not, and the people who work for him, or people in at the Pentagon, are not going to do certain things, okay, relative to paramilitary operations, for example. They would say, for example, look, you want us to go and kill somebody overseas, okay? There's an executive order that the president apparently signed after 9/11 that sort of said the executive order against assassination does not govern this area. And remember all the debates the 9/11 Commission described about whether or not you can go in Afghanistan and kill bin Laden, or do you at least to try to extract him, okay? And I'm a general counsel of, Special Forces Command. I'm not going to do it. I'm going to tell my boss that we need legal opinion from OLC. And so you tell this you go up the chain of command. Secretary of Defense tells it to the White House counsel's office goes to Office of Legal Counsel. I really am not exaggerating. I would very much doubt that you're going to find people easily willing to stick their neck out and write opinions about various unpleasant things. And these are unpleasant things. Killing, interrogating, detaining, burgling. In this area, the president cannot do it on his own, which, by the way, is a good thing. And what am I missing? The legal discourse that is shaped by all this stuff is very important.
I was wrong. It's not reading the New York Times. You associate exclusively with lawyers.
Yeah.
It's the professional curse.
Actually, I want to interject a follow-up, and I think, Elspeth is very clever, but, and I'm maybe not so much, but I'm trying to figure out who it is that you like. And I mistakenly thought before your talk, partly based on reading op-eds, that, you kind of like the president, you didn't like Congress, right? So we're trying to figure out who's the partner or the balance or the shared or the tension, the other side of proper checks and balances. And I thought you were going to complain that Congress was overstepping. And you didn't. You said Congress abdicates, which I think is right.
But oversteps by
they punt to courts.
Right.
And so you don't like courts. And, all right, I'm kind of okay with that, but you don't like courts because they're unaccountable, sometimes not public, these kinds of things. And you were calling for a good old-fashioned political debate, really. You don't want it to be in the courts. You want it to be a public, Congress wants this, and they have to make their pitch to the public, and they have legitimate rights, and the president has legitimate rights, and neither one of them has the right answer. Neither one can adjudicate it. It's, in the end, the people of the United States will decide one way or another because they'll throw some bastards out. We don't know which, right? They have to make their case to the public. But I also have the feeling you really don't like politics, right? I mean, not only do you not watch the debates, you're not interested in these kinds of things, but yeah, you just said you don't like the hurly-burly politics. But your pitch is to call for more hurly-burly politics. The way checks and balances are supposed to work is not the branches brawling with each other. It's the branches taking their clear stance to enforce their prerogatives, and the public will like some of them and not others.
Right. Well, let me say this. You actually called, you made a good call. I need to clarify a couple of things. First of all, I have a fairly nuanced view as to the proper relationship between Article 1 and Article 2. There are some people, including some of my good friends and colleagues, I just don't want to mention names because, again, it sort of tends to stigmatize people, but there are people who feel, for example, and you can probably guess who they are, that when it comes to national security, the president's power trumps Congress. I think it's very naive because the framers deliberately created. Now, there are some things Congress clearly cannot do. There are some aspects of exercise of power involving pardons, that clearly Congress cannot micromanage. There are many aspects of commander-in-chief power where I don't think anybody seriously argues that Congress can, tell the president, that you should never order troops to charge straight up the hill, but, should take the indirect approach to minimize casualties resulting from frontal assault. Incidentally, then you push it to the next level, it becomes more complicated because you have debates with people, and I'm not going to say I have debates with people, so you don't think I do nothing but that. Can Congress micromanage, how many troops there should be in Iraq versus Afghanistan? And can you set caps within the theater? Could you say you should have troops in, for example, not doing sectarian violence-related activities in Baghdad, but you can do Al-Qaeda-related operations in Anbar? That was before Anbar got but let's just say this. There are some things Congress clearly cannot do. There are some things the President clearly cannot do. But then there's a whole bunch of other things where the proper exercise, if you just ask yourself this question, is this presidential effort supportable by fair reading of Article 1? If you assume that vesting clause means I think it means that the enumerations are just illustrative. Yes. On the other hand, can Congress under Article 1 and lots of specific enumerated powers can regulate this? Yes. So both are regulating properly. If only one existed, it would be all fine. But they come into conflict. Which one wins? My view, and it's a fairly, as I said, nuanced and not a very satisfactory answer, but I cannot think of about a better one, is this. You can trench upon the other branch's authority up to the point where you essentially emasculate it. Probably not the best term, but impede its core ability to function. And that is a very fact and situation-specific example. To give you my favorite example, Congress can order that there be no use of live ammunition in peacetime for training. It would be foolish, but Congress could do that. But can Congress really order the president / the U.S. military not to use live ammunition, use non-lethal force in combat? No, cannot, because that, in the first instance, it would trench upon the president's commander-in-chief power, be kind of foolish, but okay. In every case, it would totally undermine the president's ability as commander-in-chief in wartime. And the same is with intelligence, and the same with interrogations. For example, I think Congress can ban all forms of waterboarding, can ban all forms of stress interrogation, sensory deprivation, whatever, all sorts of unpleasant things. Congress can just speak clearly with no capacious words like torture or cruel and human degrading, just all of it. I mean, I can write it in 5 minutes. Total prohibitive statute. That would not be, even in wartime, in my opinion, an impermissible intrusion on the president's power. But if Congress, for example, were to pass a statute which says the president cannot hold anybody prisoner, that would cross the line because you cannot practice armed conflict, especially since you cannot, under laws of war, or committing a war crime, shoot people who want to surrender. It's called their obligation to give quarter. So Congress cannot do this. Both are instances, so Congress can do A, but not B. Both A and B trench upon the president's power. One does it permissibly, the other one does it impermissibly. Now, there are some people, believe it or not, who are right of me, who say Congress can never do A, no B, because if it's president's, some aspect of the president's power as commander-in-chief, there's not a damn thing Congress. Boy, that view has the demerit of emasculating Congress. Because if Congress cannot do anything, then what are they good for? So it's a very tough balancing. And the way to resolve it is either for the political process, in a sense of elections, or when I say political process, Congress can impeach the president. By the way, to me, impeachment is the ultimate congressional tool, not connoting necessarily any, again, sense of if Congress thinks the president is driving this country off a cliff, they take that, seriously, by golly, they should impeach her or her. Not a question of illegality, it's a question of national survival, but you pay a huge price for it. But Congress, the framers did not mean to make this easy for both branches. Or Congress can cut off all the funds. Not micromanage the funding, but cut off all the funds. So does that make sense as far as what is the...
It's a tough standard, but it's clear anyway for what your story is. I think this will be the last question probably, so please.
Hi, my name is Robert Stallings. I'm not affiliated with anyone. Forgive me if this is a naive or ignorant question, but what I hear you saying is that the president has that your preferred system of operation would be where the president essentially can do it as he wishes in a time of war, with broad checks and balances, I think is what you said. If you also subscribe to the belief that the president can detain American citizens under the guise that they are enemy combatants, also have the authority to define what enemy combatant is, and that all of this is constitutional, therefore beyond impeachment, where is the check and or balance?
Well, to clarify, I understand the argument that's been made that the president has arrogated to himself the power to determine whether or not we're in a state of armed conflict. One. Two, who are the parties to that conflict? And the next, if you say we're in a state of armed conflict with Al-Qaeda, or a state of armed conflict, we're in a state of armed conflict with Al-Qaeda, the third question is who are the members of Al-Qaeda, including U.S. citizens? And if you give the president that power, that is horribly, and you don't provide much more than this general check, because let's face it, you didn't make this argument, but I guess you may say in the time of war, popular passions run a certain way. The people are not going to really stigmatize a successful wartime president because he's detained few folks. Incidentally, that's what happened with Mr. Lincoln, great he was as a president. We don't have time to get into it. Mr. Lincoln, not only, in my opinion, and I'm not consolidated many original sources, but I read a number of books on Lincoln, didn't just suspend, on his own habeas corpus. By all accounts, some of the people he detained had nothing to do with being Southern spies or sympathizers. They were just his political enemies. And framers wouldn't be surprised by that because, power tends to corrupt. I mean, you may think I'm not doing wonders for my own argument, but let me tell you why it's not so bad. Especially because we have now so many institutional and bureaucratic checks and balances. The president on his own can do very few things. The president has to have his subordinates vouch, certify, attest, and do things. If you got grabbed off a street, and by the way, there have only been 2 instances where, well, 3 instances if you, at Padilla, Hamdi, and Almari, where people who were U.S. citizens, well, no, excuse me, Almari is different. 2 instances I'm aware of, I think I'm reasonably aware of the cases, where individuals who are U.S. citizens get swept into this dragnet. So the notion that, hundreds and hundreds of people can be plucked off the street and designated as enemy combatant, first of all, hasn't happened, but it may not be dispositive. Second of all, the elaborate procedures within the executive branch, conducted by honorable people, officers of the United States military, who if you get swept off the street, and there's absolutely no basis for it except for some political animus, would go nuts and would not process you, would not certify you, would not confine you as an enemy combatant. I mean, we have to be cautious and careful about the possibility of abuses, but not paranoid. So and not only that, I mean, you go beyond that. There are leaks. A lot of leaks are not just done by Congress. A lot of leaks are done because of bureaucratic divisions within the executive branch. You have a CIA and DOD who don't like each other. You have DOD and State Department who don't like each other. You have different branches of services. The Army is not particularly keen on the Marines, and nobody likes Special Forces. There are all sorts of centrifugal and sort of, I call it bureaucratic checks and balances that ensure that something horribly capricious just wouldn't happen. I mean, that to me is frankly not a likely scenario in 21st century America. Now, I could be wrong. I could be horribly wrong. The question is, when you, in any kind of balancing exercise, which way do you balance? Well, practice regulatory law for a living. That is driven by your risk assessment, the consequences of some scenario, as well as its probability, and you don't tilt the whole structure towards the most implausible scenario. It's just not rational. I don't mind.
It's my understanding that over 200 people have been let go from Guantanamo after years of incarceration. If you haven't,
you are.
Mayfield, you might want to check out.
I can tell you this much as one can know from unclassified sources. If your inference is that a bunch of innocent people have been held, with all due respect, you're utterly wrong. More than 200 people have been released from Guantanamo. The vast majority of those people are released for diplomatic and sort of politesse reasons. And a goodly number of those people, sir, have gone back to fighting. And the reason we know that is because they've either been killed or captured again, or some of them have given an interview to the press. So out of some 300 people, at least 40 or 50 have gone back to fighting, which at least suggests at least these people were not innocent shepherds. Okay, and I don't mean to be passionate, but it's kind of like the glass half full versus glass half empty. Under the traditional laws and customs of war, if you determine somebody to be an enemy combatant, that person sits and sits and sits, even a POW, an honorable soldier, sits for years. Because you don't, not even for intelligence gathering reasons, because you don't want to run a revolving door operation because they're going to go back to fighting. Of course they would. Sure. So yes, we released a bunch of people because we were pressured. We released over, Canadians and all the Brits and all the Australians because we got squeezed. But I mean, every person I talked to about it, on and off a record, has said there are almost no exceptions that they were not released because they concluded they were innocent shepherds. Some were. Again, don't hold me to the numbers, but maybe 15 or 20. There's a genuine view that maybe a mistake was made. By the way, mistakes are made in every system, no matter how much due process we have. We have innocent people in death row after all the due process in the world. So yes, there are some mistakes, but the notion that which is propagated by a bunch of lawyers who do, I love it. You do a Freedom of Information Act request from a government, so you got a bunch of things, most of which are heavily redacted. And then you construct this elaborate theory that, 80% of people with Gitmo are all innocent shepherds. I don't think it's true. I cannot convince you for sure, but I don't think it's true.
I appreciate your answer, and I respect your answer, but I'd just like to end it with saying that I don't see how your answer differs much from you should just trust us.
Only with a caveat that it's not us. There are a lot of us that if you don't trust, Dick Cheney and George W. Bush or Paul Wolfowitz and Don Rumsfeld, there are thousands and thousands of very honorable men and women in the government, most of them are career, JAG officers, military officers, diplomats, who, believe me, recoil and go public and whistleblow and leak and do all sorts of things if they think something is fundamentally wrong, because that's what they do. And then we got New York Times and the Washington Post and Wall Street Journal, et cetera, bringing the news to us. Congress jumps in. Things happen. There's a lot of self-correcting mechanisms. I mean, can you look at what happened in the last several years, not to recognize that this is actually what happened? Everything has become public. All legal memos have been leaked, most of them at least. All sorts of things about abuses by the FBI, not bad abuses, kind of silly, stupid abuses about misusing national security letters, not following the procedures. All of it comes out. So, I mean, what are we horrified about? I mean, is anything not, what hasn't come out? I don't know many things that have remained. Well, again, I could be wrong.
Then you wouldn't.
Then I wouldn't. Okay. I understand there's a certain circularity in this argument.
In any event, thank you all for coming. I think this was a quite stimulating discussion. I do hope you will come back for the events in the spring. I look forward to seeing you again. And as always, I'd very much like to thank the LBJ Library for co-sponsoring these events with us. This is a wonderful venue, and we always enjoy it. And I hope to see you again soon. Let's thank David Rivkin.
Thank you for the great questions and for enduring this.